Welcome to all of our legal course participants. This is our third session for our 2024 legal course. My name is David Grasky, and I will again be moderating this evening. Very pleased and very proud to once again have, as we did last year, Elizabeth Kelley as our guest speaker this evening. As I typically do, I will begin with my Devar Torah. Adar is the last month in the Lord's calendar. The word Adar means strength in this last month of the Lord's spiritual calendar. The month of Adar is known as the most joyful month of the year. It is a month of good fortune, but it can also be dangerous as well. These attributes burst forth in the feast of Purim. Purim is a joyful feast commemorating the amazing defeat of the evil Haman in his plot to massacre the entire Jewish race in 357 BC. Here's a quick overview. During the Babylonian captivity of the Jews, King Artaxerxes of Persia was searching for a new queen. The word got out to Mordecai, a well-known Jew, who insisted that his beautiful niece, Hadassah, enter this royal beauty pageant. He gave her a new name, Esther, to protect her Jewish identity. She agreed and was sequestered for months in the king's harem and eventually selected as the new queen of Persia. During Esther's reign, Mordecai notified her of an edict calling for a total extermination of the Jews on Adar 13. Mordecai informed her of the dark heart of Haman, King Artaxerxes' right-hand man, who created and sealed this evil plot with the king's ring. Once sealed, the edict could not be expunged. Haman hated the Jews, especially Mordecai. Mordecai ordered the Jews to fast and pray and summon Esther to approach the king and reveal her identity for such a time as this. Approaching the king in those days, even for a queen, could cost someone their life. Esther fasted and prayed and was received by the king. She prayerfully invited both King Artaxerxes and Haman to two feasts, and at the second one revealed her identity as a Jew and exposed the evil Haman. The king ordered Haman to be hung and appointed Mordecai to the cabinet. Although the edict could not be changed, King Artaxerxes issued a second edict declaring the Jews can fight against their enemies. On Adar 13, instead of being slaughtered, the Jews defended themselves and lived. To celebrate this tremendous victory in the Lord, the Feast of Purim was established and has since that time gregariously enjoyed to this day. During a leap year, Purim is celebrated in second Adar, so it properly aligns with Passover. It's time to reveal our true identity as Esther did. It's time to take off our mask and be authentic with others, especially with the Lord. When we remove our masks before him, he gives us our true identity, and our destiny begins to unfold. Masks stop joy. Transparency brings light and life. When you are set free from a curse, it is so special. It's time for evil decrees to be broken. Other people may have spoken ill will against us, or we may have spoken ill will of others. This is the time to repent and to find joy going forward. And with that, I'm very pleased once again and very proud to introduce our guest speaker this evening, Elizabeth Kelley. Elizabeth is a criminal defense lawyer with a nationwide practice specializing in representing individuals with mental disabilities. She is the author and editor of 4 books published by the American Bar Association representing people with mental disabilities, A Practical Guide for Criminal Defense Lawyers, representing people with autism spectrum disorders, A Practical Guide for Criminal Defense Lawyers, Suicide and its Impact on the Criminal Justice System, and representing people with dementia. She co-chaired the ARC's National Center for Criminal Justice and Disability Advisory Board and served 3 terms on the board of the National Association of Criminal Defense Lawyers. Elizabeth is active in the ABA, serving as Vice President of the Criminal Justice Section Council, the editorial board of Criminal Justice Magazine, and having served on the ABA's Commission on Disability Rights and as an observer at the hearings at Guantanamo. She currently serves as the editor of the ABA's annual publication, The State of Criminal Justice. I'm very pleased to be able to introduce you once again to Elizabeth Kelley. Good evening, Elizabeth.
Good evening, David, and thank you so much for inviting me to appear again this year. And it's good to be with all of you. What I'm going to do during the next approximately 40 minutes is give a general overview of the challenge people with mental issues have in the criminal justice system, or if you prefer, the criminal legal system. And while I am speaking, you are more than willing or more than welcome to ask a question. And if I'm not able to address it at that point in time, I may very well say, hold that thought. I'm going to discuss that in the upcoming slide. But I would like this to be as interactive as possible. Also, as David mentioned, I have a nationwide practice. For those of you who are not lawyers, you should know that the vehicle that allows me to practice in other jurisdictions is a filing called Motion Pro Hoc Vice. And because of that, I am very sensitive to the individual characteristics of every jurisdiction. For purposes of this particular presentation, I can't necessarily put up a slide about what is the law in each of the 50 states. What I am doing, however, is using federal statutes by way of illustration. And I do know that having attended last week's talk sponsored by HINDA, we have listeners from all over the country, but the federal laws are a very good illustration of the particular points I am making. So with that, let's put on the first slide.
Okay, just a minute, please. Share screen, and where are we? 1 second. And,
There we are. We can move to the next one. The threshold issue in any criminal matter is that of competency. An individual must be competent through every stage of the proceeding, whether that is the initial charging, all the way through the moment, if you will, as perverse as it sounds, as of the moment of execution. In other words, the individual needs to know what is going on. The floor for competency was established by the United States Supreme Court in a 1960 case called Dusky v. United States. And Dusky requires that every individual possess two qualities. First of all, a rational as well as factual understanding of the proceedings, plus sufficient presentability to consult with a lawyer with a reasonable degree of understanding. In other words, an individual needs to know what's going on and needs to be able to help his or her lawyer. And competency basically is a snapshot of the accused level of functioning at the moment of the particular legal proceedings in question. And the attorney has an obligation to ensure that his or her client is indeed competent throughout the proceeding. So it could very well be that initially an individual is competent, but then for whatever reason, later on in the proceedings, loses that ability. Now, I want to interrupt and say that sometimes families come to me and say, well, he doesn't get it. He doesn't understand what's going on. He's not competent to stand trial. Well, that is a sensible definition of competency by a loved one. It is a valid observation, but it's not the legal definition. And as a practical matter, the legal definition is very, very low. Although many people do assert that they are incompetent to proceed, the way this standard plays out in various jurisdictions is the court will find that someone is indeed competent to proceed. Some of you may have heard my variation on this definition. You've probably heard the old saw, a grand jury can indict a ham sandwich. My variation on this theme is that a grand jury could find a sandwich competent to proceed. With that in mind, let's go to the next slide. If a court does find that an individual is incompetent to proceed, the court will order a period of restoration. This can either be inpatient or it can be outpatient. Now, if you think about this for a moment, you can wonder, what's the validity of this? So for instance, if someone has a mental illness and they're found incompetent to proceed, but they undergo a period of restoration, which consists of getting the proper medications in the proper dosage, and they have all the appropriate support systems surrounding them that will enable them to be successful, like housing, transportation, food, a secure environment, then their competency may very well be restored. For how long, that's a different matter. On the other hand, you may have some conditions like an intellectual disability. And that baseline is basically what that baseline is. In other words, if someone is rather low or minimally functioning anyway, they're not going to suddenly become better or smarter or more competent because of 90 days within a facility. They are who they are what they are. On another note, you may have an individual who is suffering from dementia. And the metaphor I always use with families is, your loved one may be at a certain level right now, but once he or she falls off the cliff, there is no way to bring them back up. So yes, for some conditions, you can restore them, but for other conditions, the best you can hope for is to manage their issues. Let's go to the next slide. Just as competency is the measure of one's ability in the present time, at the time of that particular proceeding, insanity is basically a snapshot of the individual at the time he or she committed the offense charged. And the insanity defense varies from jurisdiction to jurisdiction, but it's basically some variation of this theme, that there is some sort of issue which causes the person not to understand what they did or what they're accused of doing. It's an affirmative defense, and the burden usually is on the defendant by clear and convincing evidence. Now, for those of you who know your history, you may remember that John Hinckley put forward an affirmative defense of not guilty by reason of insanity. He indeed was found insane, and he was institutionalized for a significant number of years. Following that jury verdict, there was a good deal of re-examination throughout the country of various jurisdictions' insanity statutes. And for instance, at the federal level, the insanity definition was tightened, was strengthened. And one of the results of that is that, contrary to popular belief, individuals with mental illness are not willy-nilly all over the place entering pleas of not guilty by reason of insanity. They're not doing that for a couple of reasons. First of all, if they have experienced counsel, their counsel knows that prevailing on an affirmative defense of not guilty by reason of insanity is very difficult. But more importantly, in order for a not guilty plea to be truly successful, counsel needs to get a doctor in the jail as soon as that person is booked, to basically take a snapshot of that individual's level of functioning while, for instance, they are still floridly psychotic, before that person has been medicated by the jail and the outward manifestations of that mental illness are blunted. There are some conditions that usually are more successful with not guilty by reason of insanity, like schizophrenia, like bipolar disorder, like post-traumatic stress disorder, like postpartum depression. Other mental issues, like for instance, ADHD or depression, although those conditions are very, very valid, are usually not the inspiration for an NGRI plea. Next slide, please. Many times family members, no, let's go back. There we are. Thank you. Many times family come to me, and when I talk about the importance of getting an independent forensic evaluation, they say something along the lines of, well, my husband has been seen by a therapist for years, or our daughter has been treated by a therapist. And all of that is wonderful and important and needed and relevant. But for purposes of a criminal proceeding, needs to have an independent forensic evaluation by a mental health expert who can either be a forensic psychologist or a forensic psychiatrist. And the expert needs to be charged very early on with what the scope of his or her inquiry is. So for instance, the attorney, based on consultation with the family, after having spent time with the client, can ask for an evaluation for purposes of competency. By the same token, the attorney can know that this individual is relatively high functioning. So it may be difficult for that individual to be found incompetent to proceed. Indeed, that person may be so high functioning that that person is more competent, if you will, than the prosecutor, the attorney, and the judge put together. But nonetheless, there are some other issues that can and should be explored, and that evaluation is being done for purposes of mitigation, which I'll discuss a little bit more thoroughly later. It is vitally important that the expert be brought on as early as possible in the proceeding. For instance, not after a plea, not after a guilty verdict, but the expert needs time in order to render a good evaluation, and it needs to be telegraphed early to the court that there are significant mental health issues. Nothing is worse than for an individual to be found not guilty by a jury, and then right before sentencing, the attorney comes in and says, Your Honor, we need a continuance because my client has a long-standing history of autism spectrum disorder, or a long-standing history of trauma. And the judge say, where have you been? This case has been pending for 2 years. And a prosecutor might also be very skeptical and charge that the defense team is basically pulling this out of a hat, that this is being manufactured for purposes of sentencing. So the expert needs to be brought on early, not only because it takes a long time to develop the appropriate defense, but also to avoid any charges that the person is manufacturing this. Availability is a very valid concern, as we all know. Since the pandemic, mental health issues have skyrocketed, and a good forensic expert has not only a forensic practice, that is to say, a practice testifying in front of courts, but also his or her clinical practice. And because of the clinical practice, he or she is in very high demand. And certainly because the courts have now reopened and they're catching up on the pandemic backlog, people are busy. So it is very, very important that counsel ask a mental health expert and have a frank discussion with that expert. Can you indeed interview my client on a timely basis? Can you indeed write a written evaluation? Will you be available to testify at a sentencing hearing? Will you be available to sit down and meet with the U.S. Attorney's Office for purposes of getting a better plea. It's also important that the defense lawyer engage in a very thorough search of the best available expert for this particular case. There are certain kinds of conditions where where an expert with a good deal of experience in that particular area is crucial. So for instance, I do a lot of work with autism spectrum disorder, and I have a few go-to experts whom I use. And the reason why is this field is highly specialized. And I need my expert to be able to draw a line between my client's manifestations of autism spectrum disorder and the conduct charged. In other words, to be able to explain with a good deal of detail and particularity my client's particular manifestations of autism spectrum disorder and why he or she was vulnerable to committing the conduct charged. Similarly, if my client has a history of trauma and that trauma is relevant to the charges or could be relevant to a sentencing decision, I need someone with a good deal of sensitivity, someone who will not be an additional trigger for my client, someone who will in front of whom my client will feel very open and very frank. Earlier on, I said that the treating expert can't be the forensic expert. And one of the reasons why is because of conflict of interest. So for instance, think about this. If an individual has been treating my client for a number of years, my client has then been charged with this crime. And then I am asking my client to frankly opine as to my client's future dangerousness. That treating expert is going to say, it could very well say, well, of course, he or she is not dangerous because I have been treating your client for so many years. In other words, a treating expert has skin in the game and may not be as objective as one would want. And then the final criteria, or the final thing to keep in mind, is that a defense attorney may ultimately want to have a team of experts. So for instance, there may very well be an expert who does the diagnosis, and then another expert who is brought in to opine as to future dangerousness. A good expert is going to stay in his or her lane and is not going to want to discuss things that he or she is not qualified to discuss. By the same token, the attorney should spend a good deal of time going through the draft to make sure that it's factually accurate. And also, there may be additional items that the attorney wants the expert to opine on. So for instance, I may have a report by a neuropsychologist, which is a very, very thorough analysis of my client. But I may want my expert to do an addendum about my client's ability to function in prison. I'm not necessarily going to bring in a special prison consultant, but I want, for instance, my experts to discuss my client's frontal lobes, the deficiencies in the frontal lobes, and then to expand upon that and say that will equal poor decision making in a prison environment. That will equal intermittent explosions of anger in a prison environment. And it also could equal relative passivity in a prison environment, meaning the individual could not advocate for what he or she needs. And I will ask my expert first, do you feel qualified to speak about that? And then if the expert does, then he or she can weigh in. Next slide, please. We as defense attorneys sometimes flippantly call a court-ordered evaluation a drive-by. And the reason is that it's not as thorough as it should be. Now, I do want to say that some court-appointed experts are very conscientious, are very qualified, and are very thorough. But that being the case, a good evaluation will have virtually all of the following components. First of all, an extended interview, or better yet, interviews with the client. And one of the reasons why I say extended is that that expert over a period of time can get a real sense of perhaps the decompensation of a client, or perhaps the improvement of a client's condition. In the case of the latter, it might be important to say that yes, during the 2 years I have been interviewing Mr. So-and-so, he, to the jail's good credit, has received the proper medication, and I can assert that if that regimen of medication is continued, that he or she will be able to manage their symptoms. Another crucial component of an evaluation is a series of collateral interviews with family, friends, co-workers, other people who can talk about the individual. And this is important because it helps diffuse any charges that the individual is malingering or maybe exaggerating their symptoms for purposes of this case. So for instance, if you have a family who can discuss that, he has always been like this. From the time he was a little boy, we saw the following. On the other hand, if you have an individual suffering from post-traumatic stress disorder, you can have family and friends say that before the deployment, he was like this, this, and this. But after the deployment, he is now like that, and that. that before and after view is crucially important. A good expert will review a host of different documents, whether it is records from a treating doctor, a treating facility, school records, if the client has served time in the armed forces, military records. An expert, depending upon the nature of the disability, will conduct a good deal of testing. So for instance, if the individual has an intellectual disability, or has autism spectrum disorder, some very specially designed testing instruments will be administered. So too, if the individual is putting forth an affirmative defense of not guilty by reason of insanity, various testing instruments will be administered. If the evaluation is being done for future dangerousness, again, specially designed testing instruments will be administered. And if after all of this, the evaluation concludes that the individual is in fact competent to stand trial or was not insane at the time of the act, a thorough, a powerful evaluation can be used as good leverage to reduce a plea or perhaps even to get the charges dismissed, depending upon the jurisdiction, the severity of the charges, and an individual's prior record, if any. Next slide, please. I already covered this point about what an evaluation can be used for. You should also know that many jurisdictions have different kinds of what we call problem-solving courts, mental health courts, drug courts, veterans courts, and an evaluation can also be used to get that individual admitted to a problem-solving court. Now, a problem-solving court is not perfect for everyone, but more and more, our courts are taking notice of the fact that the traditional options we have in the criminal legal system, competency, sanity, our diminished capacity, depending upon the jurisdiction, are not perfect for everyone, are not appropriate for everyone, indeed come with a host of collateral consequences. And a problem-solving court may be a good way to take the person out of those traditional options and give them something that is much more appropriate. Next slide, please. Whatever the disposition of the case, it is crucially important that the family and the client work with defense counsel to chart the appropriate path forward. Now, I will say that in some jurisdictions with mandatory sentencing, the judge has no discretion, that a prison sentence is mandatory, but nonetheless, short of a life sentence, the individual will be released someday. And whether that day is today or in 20 years, the defense attorney wants to do as much damage control, particularly if the judge has the discretion, or if it is within the judge's ambit to give a minimum sentence. A path forward must be charted, dealing with a variety of different components to assure the court that the individual will be productive and, more importantly, will be law-abiding. And that path forward needs to include components like treatment, medication, therapy, particular kinds of therapy, whether it's anger management, life skills, what have you. Housing, where is the person going to live? Will the person be supervised? Will be supervised? Will someone be checking in on that individual? If the person is capable of working or continuing their education, where will that be? And how will that be conducted? And again, will that individual be supervised? It's been my experience that after presenting all of the evidence of mental issues, many judges do not want to send an individual to prison. They know how traumatic prison can be. They know it can often be counterproductive. But the defense attorney, in concert with family, has got to give the judge something that will show that this client is not going to be in trouble again, particularly in jurisdictions where the judge is an elected official. The last thing the judge wants to see is a headline in the newspaper a year from now saying that Judge so-and-so gave this individual probation or house arrest. And part of that probationary sentence was not substantial enough to guarantee that this individual would not reoffend. Next slide, please. There we go, thank you. Part of arguing for the path forward in many instances needs to be how traumatic, how counterproductive a jail or a prison sentence can be. And again, depending upon the individual mental issues, it can jail or prison can be traumatic or counterproductive for a variety of different reasons. For instance, that individual could have a fundamental inability to follow the rules. This is particularly true in cases where people have dementia. They just do not understand. And it's not as if they're trying to be deliberately defiant, but they just don't have the wherewithal to get themselves into the line for getting their meds in the morning, or when they go to eat. They have a fundamental inability to get through the line and pick what kind of cereal they want. Or they may have very, very poor hygiene habits. And because of that, they offend their roommate, they may alienate other people, they may even be the butt of jokes, beyond which they require a good deal of intensive supervision and medical treatment within the facility. So you can argue that it is an expenditure of not only financial cost, but also staff cost. And in an area where our prisons are acutely understaffed, this argument may indeed have some traction. Given, depending upon the nature of the mental issue, depending upon the court, you may very well want to bring in your own consultant to describe daily life in the facility, and then explain how, based on the individual's issues, prison could be a thoroughly inappropriate placement. But also, as I described several moments ago, your expert can also address that. But at bottom, if you don't want the court to send the individual to jail or prison, you have got to show a substantial path forward. Next slide, please. This is my concluding slide. You are welcome to reach out to me after this evening, either via email, or you can send me a message on Twitter. And I am told by the Gen Zer on my staff that I now have an Instagram site. You are welcome to follow me on Instagram. And at this point, I believe I have at least 10-15 minutes to address any questions or concerns that you might have.
Any questions for Elizabeth?
I have one.
Yes, sir.
First of all, thank you so much for that excellent presentation, which resounded deeply with authenticity and lived experience of people going into the carceral system and the concerns that, mental health professionals and, and their families have, et cetera. So one question is, my experience is entirely federal. I apologize for my cough. And what I'm wondering is if you can really make a good case that a person has frontal lobe damage, is compromised, would be victimized or act out in a prison setting, more likely to act out in that kind of a setting than in other settings. Have you had any successes, federal, state, or local, with mitigating the sentence down to probation or other?
And is your question only about frontal lobe damage, or do you
or
want
any
to
mental
broaden it?
health?
Yeah. I would like to broaden it.
Sure.
Because I think that would probably be most relevant for the audience. At the risk of being flip, it all depends. If someone is charged in the state system, I generally tell the client and the family, and by the way, you'll notice I always say family, because I am very sensitive to the fact that the family knows the individual best, and the family can be a huge resource to the defense attorney. That being said, if I'm in a state jurisdiction and there is not mandatory sentencing, my ability working with my local council to make a difference is usually pretty significant. When I'm in the federal system, not so much. First of all, the charges may very well be more serious. The cases may be worked up more thoroughly than they are in the state system. And also, I am dealing with judges whose hands are tied by mandatory sentencing. However, there are some jurisdictions, thankfully, where the U.S. attorney is open to conversation, perhaps at the initial appearance. The AUSA has seen that the accused is just a little different. The AUSA can't quite put her finger on it, but she knows there's an issue. And if I have strong evaluations by reputable experts, that may very well be a good negotiating tool such that I can get the mandatory minimum off the table. Now, again, it depends upon my client's record. If my client doesn't have a record, if my client, for instance, is a relatively young person, then the AUSA is probably sensitive to the collateral consequences of conviction and doesn't want to jam my client up for the rest of his earthly days. On the other hand, I may have a prosecutor who, whether or not he or she is elected, is junior in that office and doesn't have a lot of authority to reduce a charge, or there could be a victim in the background or a victim's family, and they absolutely refuse to sign off on a lesser plea offer. Bottom line is, you always have to try. And as I tell my clients, my families, my co-counsel up front, we will do everything we can to make the disability matter. We probably won't be, we very rarely can we get the charges dismissed entirely, but we've got to keep on fighting. And I have also noticed that just because of the prevalence of mental issues in our society, particularly after the pandemic, the awareness is heightened. And I want to take advantage of that.
Thank you for that excellent response. I do wonder if the federal courts will exercise greater latitude, if they'll be afforded to by the legislature, by the Congress.
Well, it's interesting, yeah. And for those of you who follow these things, you may know that during the past administration, the United States Sentencing Commission was basically inactive because it was unfilled. And President Biden was able to appoint a number of very, very talented individuals, including superb federal judges, present as well as past. And the federal system is now open to alternatives, diversionary options, different kinds of courts, more so than we have ever seen in the past. So I think I see progress for nonviolent offenses, first-time offenders, and I am hoping that those initiatives will broaden for people with longer records, people with more troubled history, people charged with more serious crimes.
Thank you.
Vehicle called Motion for Compassionate Release in the federal system. Different states have counterparts. And one of the few silver linings of the pandemic, Melinda, is that courts became much more generous with their granting of compassionate release. And the motions that were successful in individuals who had different kinds of mental disabilities, including autism, were those that showed that because of the deficiencies of the Bureau of Prison, an individual with a given kind of disability can not be treated, is not being treated, and in many instances is getting worse. So yeah, if you want to contact me at another time, I'm happy to talk. I also know we need to wrap up, but I need to say one thing important. In many communities, there is still a huge stigma about mental disabilities. If someone has been diagnosed and they have been managing a condition or trying to manage a condition throughout their lives, that's one matter. But particularly in the case of white collar offenses, the stigma of raising what I call mental issues, and I don't always use the term mental disabilities, mental issues, is very, very difficult. And it needs to be handled sensitively. And it needs to be put forward as a way of not making an excuse, but perhaps of explaining behavior, and then going a step further and saying that because of the particular vulnerabilities of this mental issue, jail or prison is going to be absolutely counterproductive.
Well, thank you so much, Ms. Kelley, for your excellent presentation. Thank you to the group for your excellent and insightful questions, many quite heartfelt from hard-lived experience. And advocates like Ms. Kelley are instrumental in helping alleviate the suffering of the individuals and their families. So thank you again for coming and providing your insights, your strategies.
Well, thank you. Thank you for all the wonderful work that you and your colleagues at HINDA do. And I am in awe of your initiatives, and I'm happy to be helpful to any of you in any way.
Thank you, Elizabeth, and we look forward to, we hope, having you for our 2025 legal course panel.
I shall put it on my calendar.
Perfect.
Thank
Perfect.
you. It was wonderful. Thank you, Elizabeth. Thank you.
All right.
Thank you,
Good night.
Elizabeth. Thank you, Michael. Thank you, Abby. Thank you, everyone, for joining this evening. Thank you all.
And I may join next week again just to
Always
let them in.
welcome, always welcome.
Thank you. Bye-bye.
Mike?
Bye-bye,
can we
everyone.
put the last slide on the PowerPoint up in case people want to.
Yes, I'll bring that up now.
Thank you, Elizabeth. That was really informative. Oh, she might be gone. It was very
Thank-
informative. Thank you so much.
Thank you.
Thank you.
Thank you all. and Good evening.
Thank you. Peace.
I was just about to say great to see you, Mark, but he logged off. If anyone needs this information, if they want it emailed to them or texted to them, perfectly easy to do that. If you just want to record it on your own, I have time, so please feel free. Does anyone need more time for this information?